First of all, I'd like to convey my thanks to Moitri for giving me this opportunity to share my experience with you regarding domestic violence. And since this is 8 o'clock early morning in Bangladesh, I wish you all a very good morning from Bangladesh. Actually, domestic violence in Bangladesh has become a very common phenomenon which needs our attention more than ever. I hope you all can hear me. All right, all right. Especially during the period of COVID pandemic, we saw a huge spike in the number of domestic violence. And according to one survey of Bangladesh Bureau of Statistics, almost 70% of married women and girls complain that within their marital tie, they have experienced domestic violence from their partners or member of the family members. But the problem is, for some reason, domestic violence has been taken very lightly in Bangladesh. Whenever this kind of incident are taking place, we tag it with very personal, confidential family matters and try to put it in a box and forget it. And if you go to the rural part of Bangladesh, you will find many women who believe that if you are beaten by your husband, that part of your body will not go to hell. It will not be burned in hellfire. And there are many men who propagates or advocate for various false hadith saying that the paradise of wife is under the feet of their husband. And by saying that, they try to legalize, validate the domestic violence they imposed on their partner. Unfortunately, there are some common belief that domestic violence only takes place between the marginalized and vulnerable section of the society, and people who are from the upper class, they are unlikely to face domestic violence, which is completely wrong. In my practicing experience, I have come across many cases where the woman is very hardworking. She's working in a very good organization, maybe 20 to 30 people are working under her, and she has a very good academic background and family background, but still she is suffering mutely. And I know one of my clients, she used to hide in the bathroom and lock herself when her husband used to shout on me or abuse her. So this is the scenario which is taking place all over Bangladesh. And I also know one of the very uh, powerful general whose daughter also was a victim of domestic violence. So here are actually family background, your occupation, or whether you are from a powerful family or not, it doesn't matter. It's all about, I found out, it's all about mindset up. Especially sometimes it's also the mindset of the women that they are ready to accept domestic violence for protecting their family. I still remember a day when I went to the judge court of Bangladesh and case was going on. It was regarding a restitution of conjugal right. And this restitution of conjugal right is filed when the husband or wife wants to get back her husband or spouse and they want to live together. So I still remember one lady, she was around 21 to 22 years old, and she was on the dock, and she was saying that her husband was very abusive. He was having extramarital affairs, he was having drug addiction problem, and so forth. But still, she wants to live with her husband. So when she got off from the dock, I asked her, why do you want to live with such a person who has beaten you all the time, who is having drug addiction problem, who have got extramarital? So the reply she gave me, she said, I have got two children. I don't want them to grow up without their father. So at that point of time, I was speechless because this is a problem which I cannot solve by way of any legal interpretation. This is a social problem. This is a mental setup problem. Now the question is what Bangladesh government is doing regarding domestic violence. As you know that following the Universal Declaration of Human Rights, ICCPR, CEDA, DIVA, and following all the international instruments, Bangladesh government has actually taken many steps and enacted many laws for combating violence against women. We have got penal code, which is a very age-old 1860 act, and there actually it does not directly address domestic violence. But here we have section 325, section 326, where you can go for beating. There are some sections for adultery, for concealment of information during marriage, and all other thing. But it actually did not directly address the domestic violence problem. Later on, we have some other laws, especially the Dowry Prohibition Act 2018 and Women and Children Repression Prevention Act. These two acts actually address to some extent the domestic violence problem, which are with regard to only dowry and some other rape and some other allegations. So if you ask dowry from a woman during the period of marriage, then you can go for Dowry Prevention Act. If you beat a woman or killed a woman or your wife, then you can go for the Women and Child Repression Prevention Act. And after that, the act for what we all were waiting for, that's then we have got the Domestic Violence Prevention and Protection Act 2010. Actually, I would like to highlight my comments on this act because everyone was anticipating that after the formulation of this act, this problem will be solved, but which was not actually the true sense. We could not solve the problem by enacting this act. But this act, to some extent, addressed some of the problems of domestic violence, especially Section 3 of this act first define it, and it says that domestic violence means physical abuse, psychological abuse, sexual abuse, and economic abuse. And for the first time in Bangladesh, it gave some kind of protection to the women. First of all, it gave under Section 14, it incorporates protection order. So if you feel that your partner or your husband is going to put you under domestic violence, you can go to the court and you can file an application under Section 14 saying that you need protection. Then under what circumstance court can give you this order? Court can give you restraint order from committing an act of domestic violence, restraining, even court can give the other side or the respondent order from entering your house, your premises, your office space, or the places where you usually go. Or even the court can restrain the respondents to make phone calls or send emails to you. So all this kind of protection you can give under the protection order. There is another option, which is resident order, which is very much interesting for me. Under the resident order, you can restrain the respondent or the husband not to enter his own house if you are living there. That's called shared residence. If you are living in a house and you feel that you might be a victim of domestic violence and your husband might torture you, you can go to the court and file an application. And if court is satisfied, the court can say that, look, you are not allowed to enter your own house or a part of that house where the victim is residing. So this part is very interesting. There is another part that the court can instruct the respondent or the husband to manage a different house for the victim and pay rent as well. So these kind of sections are actually very encouraging, where we can see the court can give various kind of order. And there is another section which says the husband can be directed to let the wife use the vehicle which she used to use. So you can use the car, you can stay in the same house, having a restraint order where your husband cannot go and, you know, put you under pressure or any torture or any kind of violence you will not be facing if you have this residence order. And few days back, I went to the court and we filed similar kind of application where husband was very abusive. And nowadays we are having huge amount of case where husbands are actually suffering from various kind of mental disorder, because mental health has become a very important issue now. Drug addiction problem along with mental health problem is actually aggravating this domestic violence issue. So that husband he was actually control freak, and he was trying to control his wife all the time and dictating his wife. So what we actually do, the wife had to move to the house, to her mother's house. And later on, we took a restraint order that her husband will not be allowed to come inside the house, because all of a sudden he was actually going to her mother's house and creating a scene there. So our victim, our client, was really panicked. She could not take it anymore. So we had to go to the court and take a residence order stating that, look, you are not allowed to enter your wife's house and make a scene there. Another thing you can get under the resident order, the victim, most of the time this happens in Bangladesh, that when the victim leaves the house of the husband, they actually left all their belongings, including certificates, their valuables, and sometimes, their lifelong earning. I still remember a case what we were doing. We were actually fighting for an Indian victim who got married in Bangladesh, and we filed a case of habeas corpus to protect her and her child. And actually, the writ of habeas corpus is filed when someone is unlawfully detained. And she and her child was unlawfully detained in Bangladesh. She didn't have anyone in Bangladesh. So somehow her sister actually contacted our seniors, and we file a public interest litigation under the writ of habeas corpus. And later on, court directed that, look, you have to, the custody of the victim and her child was given to us, and we arranged a separate residence for them. But when she left the house, she actually brought a jewelry around 50 lakhs of taka, 50 lakhs of rupees, which was her lifelong earning in India. And when she left the house, she didn't bring it with her. So when she was put in our custody, she didn't have anything in her hand. So all the jewelries were within the possession of her in-laws, and she was actually penniless. So when this kind of scenario is happening, we can also go to the Domestic Violence Protection and Prevention Act and bring out the jewelries by the order of the court with the help of a protection officer under the residence order. There is another provision which is very important, that is compensation. You can also claim compensation under Domestic Violence and Prevention Act under Section 16. So if there is any personal injury, financial loss, psychological damage, or damage to movable or immovable property, then you can also claim compensation. And in this regard, I would like to refer another case we actually did in our court. That story is very heart-touching. That lady, she used to work in a very good bank, HSBC Bank. I think you all have, this is an international bank. And she was actually in a very good post. She was an AVP, Assistant Vice President. So during the continuation of her marriage, to look after her children, she gave up her job and she became a homemaker. Later on, her husband actually, they had one big land in both of their name in Bosundhara city, in Bosundhara area. And Bosundhara area is one of the posh area in Bangladesh where the value of land is very high. So the value of that land is around 5 crore taka in Bangladesh, Bangladeshi taka, and around, so 2.5 or 3 crore taka was the valuation of that land. What her husband did, just because 1 month before giving divorce, she convinced her wife, our client, that she needs some money to carry on his business. And under the good faith, that lady transferred that whole amount of land, amounting 3 crore of taka, to that in the name of her husband. But it was a pre-planned action. He knew from the very beginning that he was going to divorce that lady just after 1 month. So he pre-planned it, and he actually divorced her just after 1 month after the making the gift of the property. So for that land, we filed a compensation amounting 2.54 in the court of law. So this kind of actually thing you can claim under the Domestic Violence Prevention and Protection Act. There is another thing which is actually has got some kind of overlapping jurisdiction, I would say, that is custody order. Custody order means when a victim has got a children, you can claim custody order under Section 17, and under that section, court can give you interim custody of your minor son. Because when actually agitation takes place between husband and wife, husband sometimes husband detain the child, and they do not allow the wife to see her minor child. Usually it comes under the purview of family matter and family court, but still there are some option in our Domestic Violence and Prevention and Protection Act where you can claim the custody of your child as well. So this one is very interesting. And under Section 13, you can also claim interim order. Interim order is very important in a sense that when you are claiming interim order, interim protection or resident order, you can do the hearing ex parte. That means without the absence of the other side, you can claim protection order. And court, after going through the document, if the court is satisfied that you need immediate help or immediate protection order without hearing the other party, the court can grant you interim protection or residence order. So we just did last week, we did one kind of, we received one order from this kind of nature where the court was convinced that husband was going to the house of the wife and creating scene, and he was trying to take away the minor child. Even from the bus stop, he actually tried to take the minor child from the bus stop where actually he goes to the school. So we took an injunction order, interim injunction order, until the submission of the written statement. The interim injunction order is given by the court for the protection of the minor child as well as her mother. So we have got some interesting feature in this law, which actually I believe gives some protection to the women, but still it failed to usher in the expected result. But why? So now I'd like to highlight the loopholes of this act, why it failed to get the expected result. First of all, here we have got punishment. We have got punishment for what? We have for violation of protection order up to 6 month imprisonment or fine up to 10,000 BDT or both. So if anyone violates any protection order or resident order, then there is provision for punishment. But is there any punishment for domestic violence? No. So when you are actually physically torturing someone, mentally torturing someone, you cannot get any punishment there. You can only get protection order, resident order, and if the other side violates the order, in that scenario, you can claim that look, punishment has to be inflicted. So that's the problem. The people do not want to go there because there are some women who are looking for punishment. Because I know a case where a victim, she had been in her marriage, abusive marriage for 30 to 40 years. After 40 years, her husband got involved with her secretary, and he was very abusive from the very beginning. He was torturing her mentally, and all of a sudden he sent her a divorce notice. And you know that in Bangladesh, according to Muslim law, what a woman gets when she gets divorced, she will get the dower money, she will get 3 months maintenance. And most of the time when the marriage is like 30 to 40 years back, the dower money is very little. I have gone through some nikah nama where the dower money is 5,000 taka. So what the woman is getting after living a life in hell with her husband, with her abusive husband, she is coming out empty-handed. So in this kind of scenario, sometimes women claim punishment, which is not offered in this act. So people are less likely to go to this act for getting any relief. Another thing is awareness. The thing is, this Domestic Violence Prevention and Protection Act is something no one actually knows about it. Even when we go to the judges and court, when we file our application in the court says that we hardly find any application under this act, because advocates doesn't know how to file this case in domestic violence. Even the magistrate where we file this case, it is a new act for them. So we are missing orientation here. So there should be some kind of training program or the orientation program for the advocates, as well as the magistrate, so that they get to know this act so that they can implement it. Otherwise, the problem is when a client is coming to me, I know about this act, so we shortly call it DV Act, Domestic Violence Prevention Protection Act. So we shortly called it DV Act. So we file a case under DV Act. But what other lawyers doing? they are filing actually a false case. What they are doing, they are filing case under the Dowry Provision Act, under the Repression of Women's and Children Act 2000. And what is happening that they are mentioning various false claims that the sometimes that the girls was beaten or the women was beaten for dowry, which was not the case. It was a simple case of domestic violence where beating or something like that was might not be or dowry was not involved. It is happening where the man is not asking for dowry, but he is very abusive, he is very torturing. It's happening. But most of the time, the cases are filed under Dowry Prevention Act, Repression of Women and Children Act, and no one actually, because no one actually knows about this act. So the most important thing is we have to let people know, including the lawyers as well as judges, that look, we have got a wonderful act where you can give various kind of protection, and you should take resort to this act instead of filing false case. Because at the end of the day, if you are filing false case, there is also punishment for filing false case, both under Dowry Provision Act and Repression of Women and Children Prevention Act. So we are having various kind of problem for this thing where the judges are not aware. Especially, I can still remember the case where we claim for the compensation. Just few minutes back, I was referring a case where we claim for a compensation for a woman whose land was transferred to her husband just before one man. And you won't believe that we actually went in 4 different courts. The first court we went, he transferred the case to another court, then it was transferred to another court, then it was transferred to the number 4th court. Why it was happening? Because the claiming compensation for transferring of property under DV Act, this was the first case filed in Bangladesh by us, where we claim compensation. It was never done before. So because no one knew it, no one actually tried to explore these avenues, but we decided, look, we should not let this go unpunished. We have to set an example. So that's why we filed a claim under compensation. But the problem is judges they got confused how to give compensation under this act. What evidence should we look at, and whether it is possible to give compensation? How are you going to prove that you actually transferred, you did not transfer the land voluntarily? How would they know? So what they are doing when they are facing this kind of complexity, they are transferring the case to the district judge. Then district judge was allocating the case to different court. When the another court is looking at the case, he actually finds out that there are some new materials involved there. So he transferred the case to another court. And after changing 4 courts, this is very, what should I say, disappointing even for us, that the client actually gave up. Because each and every day when you are filing a criminal case, you have to be, the client has to be present in the court. So she was working in a school. So each and every day, we used to have date in each and every month. So once in a month, she has to take her leave from the school and she has to go to the court, which is located in Shodroghat. And it is a very far corner of Dhaka city where it's huge traffic jam. It used to take 2 to 3 hours to visit from Uttora. And every month she used to go there. And what she was actually getting to know, that the court has given another date or the case has been transferred. So after changing of 4 courts, she was totally disappointed and she actually gave up and we had to withdraw the case. So this is the scenario which is going on because the judges who are actually the magistrate is the first step of the criminal justice system. They are the very new judges who are actually appointed recently. They are appointed as magistrate, and then we have senior assistant judge, then additional as joint district judge, then we have additional, and then we have district judge. So they are the first ladder of the judicial system. The problem is, since they are not aware of this law, they don't know how to deal with it, and the clients or the victim are paying the price. Another thing is, we always advocated during the enactment of this act that it should be given to the family court. The power should be given to the family court because the family court was actually dealing with the family laws issue. They will be able to understand the family dynamics, or it should be the family issue should be given to a senior judges. We always say that because the family court or the magistrate court, as I mentioned earlier, the junior judges are sitting there, the magistrate, they're the first ladder of the criminal justice system. So actually, most of them are not even married. Honestly speaking, they are within their 30s. Most of them are not married. So the problem arises that when you are not married, will you be able to understand how the relationship between the husband and wife, can deteriorate? After getting 12 years of marriage, I know how to avoid confrontation with my wife very politely, very softly, and how to save myself as well. So they need to know that as well, because it's all about mental setup. So when we are raising any problem before them, sometimes, not all of them, but sometimes it happens, they fail to realize the gravity of the offense, the gravity of the domestic violence the victim is facing. So it is another problem. The magistrate court is actually dealing with this kind of problem. There is no special court, and it is one kind of criminal court. It is actually the criminal court. The magistrate court actually deals with the criminal cases, and it is another problem. Like, the victims are not comfortable to go to a criminal court, because when you go there, you will see your surroundings. You'll have, the rapist, you will have the thief, you will have the, dacoit and all other criminals around you, and there is no space for sitting. So the environment is not women friendly. So this is another problem. These people don't want to file any case under DV Act. uh, Another problem, we are nowadays we are facing another new dynamics in DV Act. Now the men are claiming, sometimes, not sometimes, in many cases, men are claiming that they are becoming a victim of domestic violence. But under the DV Act, only a woman and a child can file a case. I still remember a case where a former ambassador came to our chamber at night. It's around 7 or 8 o'clock, and his shirt was torn, and he had bruises and marks of scratching all over her face, and on the neck. And he was actually violated by her third wife, and he was a old person, like almost around his 60s, and he got married to a woman who was around 35 or 40 years old. And for some reason, they were having conflict of opinion, and he was actually violated by her wife and beaten by her wife. And he came to our chamber, and he was shivering at that time. I still remember the day, because the men are claiming that the government of Bangladesh has enacted many laws for preventing domestic violence and gender-based violence against women. And some laws are very effective. Especially, I would like to quote the Repression of Women and Children Repression Prevention Act 2000. That law, under that law, if a case is filed, if it is filed in the police station, the police can arrest you without any warrant. This is cognizable offense. And if it is filed in the court, then court is likely to give warrant of arrest. So he was actually shivering under the apprehension that his wife might file a false case against her under the Dowry Provision Act or the Repression of Gender. So this kind of incident are taking place, and men are claiming that they are being violated. They need protection, but they cannot go anywhere, especially under the domestic violence. And if you go to the Facebook, there you will find a forum called Men's Right Forum. This men rights forum actually advocates for the cases where they are becoming a victim of domestic violence, especially some people who are living abroad. Sometimes they are becoming victim of domestic violence, in a sense that the wife who is living in Bangladesh, they are claiming money for them, and they cannot send money. When they cannot send money, they are threatening to file a false case against them as well as their family. And sometimes we have found many cases where actually a woman is being tortured by women, like the mother-in-law is tortured by her daughter-in-law. And when a false case is filed against a man, we always notice that a false case is not filed only against the man. Most of the time, her mother or his mother or his sister is involved. So when someone goes to the court for claiming anticipatory bail, we sometimes saw a man is standing just after him, his mother, and after him, after her, his sister is standing. So sometimes women are being tortured or being violated by the women themselves in Bangladesh. And another thing, uh, I found it very surprising and disappointing uh, with regard to Hindu and divorce, Hindu and Buddhist community. Under the Hindus and the Buddhist community, they cannot file for divorce. A Muslim woman can divorce her wife if she has got delegated power, or we call it talakat office. And if she is in an abusive relationship, or she thinks that her husband, she is becoming a victim of domestic violence, she can divorce her husband unilaterally if she has got that power. And most of the time, nowadays, it has become a trend. In the Nikanama, the power is given automatically. Or we always stick that, is there any power to give divorce? The Kaji always stick that. But the problem is that I have found many clients coming to me who are from Hindu community or Buddhist community, and they are in an abusive relationship. Her husband is very abusive, very torturous, and she wants to get rid of her husband. But the problem is, under Hindu or Buddhist law in Bangladesh, there is no provision for divorce. Though in India, so far my understanding goes, the Hindu women can divorce, but we tried to actually change the law, but it was not taking very actually positively by the community itself. And I still remember I actually conducted a seminar on this reformation of divorce law, and some part of the community, actually there is a split, some part of the community said that, look, you are a Muslim, you are not allowed to interfere in our religious belief. So that's another problem, where actually the Hindu and Buddhist women are actually suffering mutely because they cannot get rid of with a toxic marriage, and they have to endure it. And I hope that this law will change one day. Another problem is that domestic violence, when a domestic violence takes place, there is provision for safe house, safe place under this act, but we don't have enough shelter house. There are some government shelter house which are already occupied. So when a woman is suffering or become a victim of domestic violence, where she's going, she cannot, in many cases, she cannot go back to her parents, because there is a strange mindset up in Bangladesh that you have to carry on your family life at any cost. Some women doesn't get support from their parents as well, and some women doesn't have their parents, maybe they are not living, maybe they are dead. So where she will go? We don't have enough shelter house to support them. This is another problem for domestic violence victim. Another thing is that power of police under this act. Under this act, police cannot actually arrest. Whenever you go to the police claiming a domestic violence issue, police can only suggest you that you can file an application in the court. That's all they can do. Or they can call the husband and they will say, look, this is a family matter, you should not beat your wife, and something like that. But police, the power of police is very limited under the DV Act. That is another loopholes. Another problem is that secrecy. When a family matter is involved, there are various kind of things which women or the victim doesn't want to say in public. Though we have camera trial in under this act, but the magistrates are less likely to do camera trials. It is actually discussion of the magistrate whether to hold camera trial or not, because the word say the magistrate may hold the camera trial. So when the word may is used, it goes to the discretion of the judges. And just last week we submitted an application for having a camera trial, but the magistrate was reluctant to accept it, and they do have their reasons, because in a criminal court it is actually packed. They have got so many cases. If you want to conduct a camera trial, you have to go back to your room, you have to call the victims and the other side, and it will take, for one case it will take half an hour. And where they have 200, 300 cases in their cause list, it is actually practically sometimes not possible for them. So this is another problem, that women or the victim doesn't want to go to the court and say their sufferings in publicly, especially in a court fully packed with unknown people. This is very much uncomfortable. So this is another reason why actually people do not want to file any case under the domestic violence. Another thing is that is we call actually motivation. We need to change our mindset, because whenever a domestic violence takes place, for some women, they think the only solution is sending your husband to jail. And when this is the mindset up, they tends to go for different act where there is jail punishment, like Dowry Provision Act or Repression of Women and Children Prevention Act. Because if you file any case under this act, there is highly likelihood that your husband or your in-laws will go to jail. Since there is no provision for this kind of thing in Domestic Violence Act, uh, some women are not very interested in filing this case, and I take the ownership or onus on us as well, because sometimes when a victim goes to the lawyer, some lawyer says that, look, file the case under the Dowry Provision Act or the Nari Shishu Nirjatan Daman Act, because it will send your husband to jail. So we are actually the person who are misguiding them. And I still remember a case where a actually actress, a very well-known actress, came to us, and she was saying that she went to the police station, and police suggested her that, look, file a case under the Nari Shishu Nirjatan or the Women and Children Repression Act, and your husband will be on the run. And she had to file a false case saying that her husband was claiming dowry from her, which was not the case. So this is the scenario. So we need to change our mindset up. We, the advocates, need to take responsibility. We need to tell them that, look, it's not good to file the false case. You have a different act where you can have some protection, so go for that. So this is the situation of domestic violence law in Bangladesh. Now I'd like to highlight another thing, which is marital rape. Unfortunately, the marital rape is not fully recognized in Bangladesh, because under Section 375 of Penal Code, it is saying that sexual intercourse by a man with his own wife, the wife not being under 13 years of age, is not a rape. So if your wife is over 13 years of age, it is impossible legally to rape her, even her consent is not there. So this is one huge gap in our laws, where husbands are sometimes forcefully raping their wife. And according to one statistic of Bangladesh Statistics Bureau of Statistics, 27% of 20,000 married women, they actually conducted a survey, and it was found that 27% of the married women complained that their husband actually were physically or sexually abused them. And sexual abuse also included in the domestic violence as an offense, but still the age limit is 13 years. That's the most challenging thing. And I still remember a case where one small girl named called Nurun Nahar, she was 14 years old, and her husband was, I think, 35 or something like that. And he actually had sexual intercourse with her, and she died of bleeding at the end of the day. And after that, there was a huge agitation in Bangladesh claiming for the reformation of this patriarchic law. And later on, there is a writ petition filed 7758 of 2020. It was filed by a number of human rights organizations, including BAST, Nari Pokho, Manusher Jonno Foundation, and a rule was issued saying that why this law should not be declared as unconstitutional, because it is discriminatory, and it was against right to life, which is one of the fundamental rights of secured under the Constitution of Bangladesh. So a rule has already been issued, but the problem with the Bangladesh judicial system is that we have got very few judges, and it will take a long time to do the rule hearing. We don't know when this case will be heard, but as long as we are not getting any decision from the Honorable High Court Division, this law is still valid, because the law was not actually stayed. There was only a rule issued. Rule means show cause. So court actually show cause the concerned government authority why the law should not be declared as illegal, unlawful, and unconstitutional. But still, law is still valid. Still, marital rape is valid in Bangladesh if she is more than 13 years of age. So these are the problems we are dealing with within the jurisdiction of Bangladesh, and I believe a day will come when we'll be overcome this problem.